Lockhart.
Yes, hello?
Are you, you've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
Yeah, so I am Jamil of the family Lockhart. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution.
Sovereign citizen arguments completely unravel inside a real courtroom. This is the conclusion to a case where Judge Perkins is once again faced with a defendant who believes the Constitution is some kind of cheat code, one you can wave around to escape traffic laws, licensing requirements, and reality itself. Meet Jamil Lockhart, a self-described Jamil of the family Lockhart, who has returned to court armed with internet law school theories, misquoted constitutional clauses, and the firm belief that if he just asks the word jurisdiction enough times, the charges magically disappear. What starts as a routine traffic case quickly spirals into constitutional gymnastics, accusations of secret jurisdictions, and one of the most patient judges you'll ever see trying repeatedly to bring things back to planet Earth. This isn't just about a license or insurance. This is about the dangerous confidence that comes from misunderstanding the law, the clash between courtroom procedure and conspiracy thinking, and how fast things can go sideways when someone refuses to answer a simple question. Pay close attention, because the judge gives him chance after chance, and each one is wasted in spectacular fashion.
So in which of these two criminal jurisdictions does the court intend to try me?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings and conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct
you have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction. Maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules. The whole book is ascertainable to you online.
Sir, the Sixth Amendment grants
I'm not required
to inform me of the nature and cause of any action brought against me. And right now, you're denying that right.
I'm going to tell you, sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving, drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration.
Understand the
maximum possible. Don't interrupt me, sir.
Okay, good. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court. As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules, the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
You
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question.
Your Honor, I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of a constitutional right cannot be converted into a crime, sir.
And here we go. This is where the sovereign citizen script officially kicks in. Notice how Lockhart isn't responding to the charges at all. Instead, he's trying to force the court into a philosophical debate about brands of jurisdiction that simply don't exist in this context. Admiralty law, military tribunals, enclave clauses, these are buzzwords pulled straight from online forums, not real defenses to a traffic case in Michigan. The judge, meanwhile, is doing exactly what judges are trained to do: identify the motion, rule on it, and move the case forward. That's why the motion to dismiss is denied so quickly, because subject matter jurisdiction here is not mysterious, secret, or hidden. It's clearly laid out in statute and court rules. The problem isn't that the court won't explain, it's that Lockhart doesn't like the explanation because it doesn't support his narrative. This pattern is important because once you see it, you'll recognize it repeating over and over again.
The way you speak to the court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion,
under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
Sir, there's only two jurisdictions which this court can operate under.
Just like any other, you're going to be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty law?
This is one of the most common and most misunderstood arguments sovereign citizens make, invoking the Sixth Amendment as if it requires the judge to personally tutor them in law until they're satisfied. The Sixth Amendment guarantees notice of the charges, not agreement with them, and definitely not endless debate about whether the court exists. What's fascinating here is how Lockhart keeps reframing his confusion as a constitutional violation. He's not actually unclear about what he's charged with. He just refuses to accept the legal framework those charges exist within. And the judge is being remarkably patient, repeatedly pointing him toward public court rules, which is exactly where jurisdiction is defined. The courtroom isn't hiding anything. It's just not playing along with the fantasy that criminal courts operate under secret maritime law. This moment sets the stage for everything that follows.
The record for Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen, I'm not getting
I cannot
all
move
that.
forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial day. I'll hold that dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint one.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you got to go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're going to win at this position, that's going to be up to what you say in your brief and how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a common law criminal procedure
I've given you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for.
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please direct me?
And there it is, the moment Lockhart claims he's been asking for all along. The judge clearly and plainly states the charges: driving without a valid license, no insurance, and improper registration. That's it. No mystery. No secret contracts. No international treaties. Just basic traffic violations that apply to everyone using public roads. But notice what happens next. Lockhart doesn't pivot to addressing those charges. He doesn't ask about evidence, procedures, or trial strategy. Instead, he immediately loops right back to jurisdiction. This is the tell. When someone claims they just want to understand, but refuses to engage once the explanation is given, it becomes clear this isn't confusion, it's obstruction. At this point, the court has fully satisfied its constitutional obligation. Everything after this is Lockhart choosing confrontation over resolution.
I've already directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not going to keep going back and forth with you, sir. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case.
This exchange perfectly encapsulates why Admiralty law arguments fail every single time. Admiralty law governs maritime activity, ships, oceans, navigable waters, not a 2011 Jaguar driving through Detroit. The judge's response isn't just sarcastic, it's legally precise. No water, no Admiralty jurisdiction. Period. What makes this especially interesting is that Lockhart treats these arguments like magic words. He believes if he can just force the judge to choose between imaginary legal categories, the case collapses. But courts don't operate on hypotheticals, they operate on statutes and precedent. This is also where you can see the judge beginning to set boundaries. The patience is still there, but the tolerance for circular arguments is wearing thin, and that shift matters going into the second appearance.
And for the record, I would just
in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the inter-party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time. And there's been no evidence of any jurisdiction, and I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest. And you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're going to have.
This is one of the most dangerous misconceptions in sovereign citizen ideology, the idea that laws only apply if you personally consent to them via contract. The judge shuts this down decisively and correctly. You don't need an international agreement to be bound by traffic laws. Participation in public systems, like roads, courts, and protections, comes with obligations, not optional terms and conditions. The no contract argument falls apart instantly because if it were true, no laws would be enforceable at all. Anyone could simply declare themselves exempt. The judge's explanation here is critical. Rights and responsibilities are inseparable. You can't demand constitutional protections while rejecting the authority that enforces them. This moment is the intellectual collapse of Lockhart's entire position, even if he refuses to acknowledge it.
I didn't say I was going to put a warrant. I said, if you're telling the court that you're not going to come back to any court dates, then that's up to you. All I can do.
What I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And the prosecutor can't provide that. And it seems like there's a bias going on here because flat on its face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution. And what I'm asking is
what you're saying in essence is that I don't have any authority.
I'm asking you to prove your.
This is where things become genuinely dangerous for the defendant. Judges have enormous discretion when it comes to courtroom order, and Lockhart is pushing every possible boundary. Talking over the judge, refusing to answer direct questions, and challenging authority in open court isn't activism. It's a fast track to contempt. The judge is actually giving him an out here, explaining the consequences and attempting to move forward procedurally. But Lockhart interprets restraint as weakness and doubles down. This is the moment where ideology collides with reality. Courts don't debate their own existence and they don't wait forever. At this point, the case is no longer just about traffic violations. It's about whether the defendant will comply with basic courtroom rules at all.
I'm asking you to prove your authority. I'm trying to understand where your authority is coming from. And you're failing to do so.
Read the Michigan court rules, read your statutes, read the Constitution over again, And you'll find
I'm
that.
not, as I said before, I'm not asking you for legal advice or where
And
to
the
go.
Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law?
All right, we're gonna give them a trial.
And you will not answer that question. Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you, whatever your claim is that you're stating, you speak to the court through motions. I want that, and those motions that you're entertaining on the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis
so
or ground.
that the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. But I don't think that the way that you're going, that you're even if they show you documentation like it is in black and white, you're not going to believe that anyway. That's the perception that I'm getting from you. So I'm going to set these dates. It's going to be up to you whether you want to come to these court hearings or not. And if you don't come to the court hearings, the only recourse I have is to issue a warrant for failure to appear. Okay, so
sir, I still have this same question that you keep failing to answer. And without that question being understood,
and that's it. I'm done talking about it. Okay, that's it. So I'm going to set a
let the record show that the judge has refused.
Listen, sir, don't interrupt me again. Okay? Don't interrupt me again. Let's set a motion date for.
I do not consent.
Please do not say anything else, sir.
And that brings us to the end of a case that perfectly demonstrates the difference between legal rights and legal fantasies. Judge Perkins made the charges clear, provided procedural guidance, and repeatedly directed the defendant toward the proper way to raise objections, through written motions supported by law. Instead, Lockhart chose repetition, confrontation, and internet talking points over substance. The takeaway here is simple. Courts operate on rules, not rhetoric. Jurisdiction isn't a magic word, and misunderstanding the law doesn't invalidate it. This case wasn't dismissed because the judge lacked authority. It moved forward because the authority was unquestionable. If you found this courtroom exchange as shocking, and honestly as frustrating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real-world legal reality checks.
I'm exercising my Sixth Amendment right. The Sixth Amendment, exercise of an amendment right cannot be converted into a crime, sir.
I'm holding you in contempt of court, sir.
As I stated before, I'm trying to understand the jurisdiction of the court.
I'm not going to deal with you. You're going to jail.
Pursuant to
let's pull out the contempt
the Sixth Amendment.
Whatever paperwork we need to do and fill it out, we're going to fill it out this time. I'm holding your client. Well, Mr. Berry, you are, I guess, not representing this client because this client is probably, do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail. Do you want the representation or not?